and quotes extensively from various authorities. The reasoning will be of interest mostly to lawyers only. I accordingly do not intend reading it out in open court today, particularly where we're without air conditioning at the moment, and it's going to become unbearable soon. Hard copies of the judgment will be made available to the state and both defense teams immediately when I adjourn these proceedings. Electronic copies of the judgment may then also be obtained from our registrar by providing her with an email address, and it will be sent to you. What follows then in these proceedings is a summary of my main findings in my judgment. At the outset, I should state that it's unusual for me to reserve judgment in an application for leave to appeal. I would have preferred also not to have reserved in this matter. However, the issues which arose before me for determination were not confined to the application for leave to appeal. Various additional applications also featured. I have identified 8 categories of issues which arose and which I consider necessary to deal with. They will, in the interest of brevity, be summarized in a very abbreviated form, recording mainly the conclusions I had reached, rather than setting out in detail the reasoning which led to those conclusions. Anyone requiring the reasoning is invited to peruse the full judgment, and as I've mentioned earlier, it's available in electronic form upon request. I commence before summarizing the conclusions that I have reached with a brief reminder of the fundamental findings I had made in the main judgment, which dismissed the special plea regarding the alleged lack of title on the part of Mr. Downing to prosecute in the criminal trial. Again, my summary of these fundamental findings will be brief, as they've been explained in detail and repeatedly in the main judgment. What was before this court to decide in the main judgment was the special plea in terms of Section 106(1)(h) of the Criminal Procedure Act 51 of 1977, which had been raised by Mr. Zuma to the effect that Mr. Downer did not have the title to prosecute. That was all, nothing else. Specifically, I was not required to adjudicate an application to have Mr. Downer removed as the prosecutor in the trial based on any alleged threat to Mr. Zuma's fair trial rights. I am enjoined by law to decide only the issue before me. That is the effect of the principle confirmed, amongst others, by the Supreme Court of Appeal in National Director of Public Prosecutions versus Zuma, Mbeki and another intervening. I am bound by our system of stare decisis, or previous decided cases, to follow that principle. The primary issue for determination in the main judgment, more specifically, was whether Mr. Zuma's complaints, assuming that they could be established, would result in Mr. Downer lacking the title to prosecute as contemplated in Section 106(1)(h) of the Criminal Procedure Act. That inquiry in turn depended on the meaning to be assigned to the words, quote, that the prosecutor has no title to prosecute, unquote, in that provision of the Criminal Procedure Act, as interpreted and determined by our courts. That the term, quote, prosecutor, unquote, refers to the person actually prosecuting and not the state has been the law binding on this court since at least the decision in Ndluli versus Wilkin, N.O. No doubt arises in that regard. As to what is meant by, quote, title, unquote, was decided authoritatively in Porritt and another versus NDPP and others. The ratio decidendi, or reason for the decision, in Porritt is clear. Complaints of an alleged lack of impartiality or bias on the part of a prosecutor, whatever the grounds may be for such lack of impartiality, do not affect a prosecutor's title to prosecute for the purposes of Section 106(1)(h) of the Criminal Procedure Act. The decisions in Ndluli and in Porritt are both decisions of the Supreme Court of Appeal and binding on this court, even if they were wrongly decided, which I'm not persuaded they were. Those decisions are dispositive of the special plea. They are also dispositive of the prospects of success of the application for leave to appeal, which I was now required to decide. And they are also material to the outcome of various other applications pursued in conjunction with, and some conditionally in the alternative to, Mr. Zuma's application for leave to appeal. I turn then to the 8 categories of specific issues that arose for determination and alluded to earlier, and I comment on those as follows. The first issue was the allegation that I had committed an irregularity in fixing dates for the exchange of affidavits. Mr. Zuma complained that I had directed that affidavits be filed in the application for leave to appeal, which he said he found strange and amounting to, and I quote, an irregularity, unquote. I would also have found that strange, because I've never directed that affidavits be filed and exchanged in an application for leave to appeal. In this matter too, I had not directed that affidavits be exchanged in the application for leave to appeal. What I did do was to fix dates for the exchange of affidavits in regard to the application brought by Mr. Zuma for further evidence to be adduced on appeal, a separate and distinct application of an entirely different complexion, in which Mr. Zuma's attorney had filed a founding affidavit with his application. Shortly after that application had been filed, the state indicated that it wished to oppose that application for further evidence and would file an answering affidavit setting out the basis for such opposition. That procedure would accord with normal practice and would also be consistent with the provisions of Section 316(5) of the Criminal Procedure Act. The directive which I subsequently issued, properly construed in the context of the correspondence that was exchanged with the parties, and having regard to the purpose for which the dates were fixed, did not direct that the affidavits be exchanged, or that any affidavits be exchanged in the application for leave to appeal. It dealt with the application for further evidence to be adduced. There is no founding affidavit in the application for leave to appeal to which an answering affidavit could conceivably have been filed as a response. The suggestion that, contrary to accepted practice and irregularly, I had required that affidavits be filed in the application for leave to appeal was factually incorrect, unfounded, and with respect, opportunistic. But even if the exchange of if the exchange of correspondence, which I had with the attorneys for the parties, which are recounted in verbatim in my judgment, could be construed as fixing dates for the exchange of affidavits and the application for leave to appeal, this would not amount to an irregularity, as it would not impact on the proper administration of justice. The directive relating to the exchange of affidavits followed after the main judgment sought to be appealed against had been delivered. The alleged irregularity could therefore not taint that judgment in any way. The objection to the alleged irregularity was accordingly, for these reasons and others set out in the written judgment, and which I will not now repeat, dismissed. The second issue related to an alleged conflict of interest on the part of Mr. Downer as the deponent to the answering affidavit. The objection by Mr. Zuma here related to Mr. Downer having deposed to the answering affidavit in opposition to the application for further evidence on appeal, and him also being the person who is alleged to have no title to prosecute, thus giving rise to an alleged conflict of interest, which it was said should have caused him not to depose to the answering affidavit. In my view, Mr. Dana was the person directly affected by the various accusations made against him in the special plea proceedings. He was also best qualified to respond to the allegations in the founding affidavit in support of Mr. Zuma's application for further evidence on appeal. There is no conflict of interest, and indeed, his interests coincide with that of the state. There is no substance to this ground of objection, and it is likewise dismissed. The third issue which I've identified is whether an appeal against the main judgment dismissing the special plea that was entered is competent at this stage of the criminal trial. That is, before a verdict is reached, I beg your pardon, as to the guilt or innocence of Mr. Zuma. This is an issue of some complexity in the light of changes in legislation. My judgment commences by, with reference to numerous authorities, reiterating the undesirability of piecemeal litigation, where decisions and findings made during a trial are taken on appeal before the conclusion of the trial, as these invariably result in delays and hence drawn-out trials to the detriment not only of an accused but any co-accused, and also the general interests of the public. I then consider the state's arguments that an appeal against the dismissal of the special plea at this stage of the trial, prior to conviction, would not be competent. In the final analysis, I conclude that if an appeal may be prosecuted before the conclusion of the trial, and although such an appeal might not dispose of all the issues in the case, the appeal must be one that will lead to a just and prompt resolution of the real issues between the parties. And stroke all must otherwise be in the interests of justice. I conclude that if an appeal against the main judgment was to be entertained at this stage of the proceedings, it would not lead to a just and prompt resolution of the real issues between the parties. The real issue being the guilt or the innocence of Mr. Zuma, and that it would also not be in the interest of justice for the appeal to be heard now. That does not mean that Mr. Zuma could not ultimately appeal the dismissal of the special plea, but only that he cannot do so now. The trial must first be completed. The relief sought by the state in the trial would be Mr. Zuma's conviction. The special plea has no direct bearing on that relief. Mr. Zuma has pleaded not guilty to all the charges, and he remains to be tried. Permitting an appeal only at the end of the trial is practical, because if Mr. Zuma is acquitted, the time spent on any appeal against the dismissal of the special plea would have been wasted, would amount to a waste of limited judicial resources, and would have no practical significance. Resorting to appeals prior to the finalization of a trial results in delay, fragmentation of the process, and the determination of issues based on an inadequate record. There are no compelling considerations to the contrary, requiring that an appeal be permitted now. It is furthermore inimical to the interests of justice to permit an appeal if the appeal has no prospects of success, an aspect to which I shall return below. A speedy trial and finality in litigation always remain vital constitutional imperatives. I accordingly conclude that an appeal, and hence an application for leave to appeal in respect thereof, should not be entertained at this stage of the trial against the two accused. If that had been the only issue in the application for leave to appeal, I might have been disposed to granting leave to appeal on the basis that the law might be uncertain on this issue. However, even assuming and proceeding on the basis that it is accepted for the purposes of this judgment that the dismissal of the special plea is appealable at this stage, I am satisfied that the application for leave to appeal should nevertheless be dismissed on the basis that it lacks reasonable prospects of success. That brings me then fourthly to the merits of the application for leave to appeal. As recounted in the summary of the fundamental findings which I made in the main judgment and which I alluded to earlier today, the issues in the special plea before me were dealt with in the decisions of the Supreme Court of Appeal in Ndluli and Porritt, both of which are binding on me, even if I was to consider them to be wrong, which I indicated I did not. I do not have a discretion in the matter. That conclusion is dispositive of the process of success of the appeal, and hence also the prospects of success of an application for leave to appeal. The fifth issue raised, and which I've identified, relates to whether the proceedings resulting in the dismissal of the special plea should have taken the form of a trial rather than being decided on affidavit. Although Mr. Zuma raised the special plea and commenced the proceedings in respect thereof by way of affidavit, he argued that a trial should have followed, where he would want to call Mr. Downer and others as witnesses and cross-examine them in regard to his concerns of possible political interference in his prosecution, the possible involvement of foreign intelligence agencies, and the like. He placed reliance in this regard on the provisions of Section 108 of the Criminal Procedure Act. I conclude with reference to the interpretation of Section 108 of the Criminal Procedure Act and Mr. Zuma's election to have pursued the special plea by way of affidavits, that there is no substance to the contention that the hearing of the special plea should have taken the form of a trial, with oral evidence being led, witnesses being subjected to cross-examination, and the like. The grounds of complaint raised by Mr. Zuma cannot, as a matter of law and binding precedent, even if his complaints were assumed to be correct, be decided under the rubric of a special plea as raised in terms of Section 106(1)(h) of the Criminal Procedure Act. It meant that the special plea could be disposed of, if you like, as if on exception. That rendered lengthy oral evidence unnecessary, irrelevant, and superfluous. The benefits of deciding the special plea on affidavits have been immeasurable, and it was patently in the best interest of justice that it be decided on that basis. No grounds have been advanced to suggest that the exercise of my discretion to determine the special plea on the affidavits was a discretion which I exercised arbitrarily or capriciously or not bona fide, and hence possibly liable to be impugned. To require witnesses to be subpoenaed even before the criminal trial proper would have commenced, for them to be cross-examined on various issues, many of which might never even be raised as issues in the trial, would not be in the interest of justice. In the sixth instance, I turn to Mr. Zuma's application in terms of Section 316(5) of the Criminal Procedure Act for further evidence to be led in the prospective appeal. As firstly, the application for leave to appeal has no prospects of success, and secondly, an application for further evidence to be led in a prospective appeal pursuant to Section 316(5) is competent only in respect of an appeal provided for in Section 316(1)(a) of the Criminal Procedure Act, that is, following the conviction of an accused, which the present is not. This application also falls to be dismissed. But further, even if but for the aforesaid reason, an application for further evidence was competent at this stage, on the facts too, it should be refused, as the requirements of Section 316(5)(b) of the Criminal Procedure Act were not, in my view, satisfied. I deal with the respects in which they were not satisfied in my judgment. The application for further evidence is therefore dismissed. The refusal of that application is also not something that requires leave to appeal being granted. Mr. Zuma would have his remedies in terms of Section 316, subsection 8 of the Criminal Procedure Act. I turn then to the issue of the special entry of an irregularity or an illegality as founded on Section 317 of the Criminal Procedure Act. The contentions advanced in this regard were, in my respectful view, ill-founded. The relief claimed under this heading concluded with a prayer that leave to appeal should be granted to the Supreme Court of Appeal in respect of an entry of various alleged irregularities or illegalities. These irregularities included, inter alia, the alleged irregularity I committed when fixing dates for the exchange of affidavits, and Mr. Downer's alleged conflict of interest, both being issues which I've dealt with earlier, as well as various other grounds which were unfortunately not clearly stated. No application for such special entries had been made previously and refused. An application for leave to appeal in respect of a refusal to entertain the entries accordingly did not arise. In any event, where an application for special entries to be made is refused, leave to appeal, as has been requested by Mr. Zuma, is not required. Mr. Zuma will have his specific remedies in terms of Section 317, subsection 5 of the Criminal Procedure Act. Even if an entry of an irregularity or an illegality had been made, an approach to the Supreme Court of Appeal in respect of such irregularities would not be competent at this stage. Section 318, subsection 1 of the Criminal Procedure Act provides that if special entries are made on the record, an appeal to the Supreme Court of Appeal may be pursued by the person convicted. But Mr. Zuma is not an accused person who has been convicted. Insofar as the replying affidavit by Mr. Zuma falls to be construed as an application, not just for leave to appeal, but for entries of illegality or irregularities to be made, that application must also fail on its merits. There are no such irregularities or illegalities as complained of, and none can be sufficiently identified with certainty and the required clarity for the formulation of such entries as required in our case law. Insofar as possible entries of irregularity can be discerned, and I'm thinking here of the directive that are issued for the exchange of affidavits and Mr. Downer's alleged conflict of interest, they are furthermore, with respect, frivolous, absurd, and insofar as they are devoid of any prospects of success, they would amount to an abuse of the process of this court, all as provided for and contemplated in Section 317(1) of the Criminal Procedure Act. The application falls to be dismissed on that basis too. Finally then, I consider the eighth and last issue, namely the question of reservation of questions of law for consideration by the Supreme Court of Appeal. The allegations advanced in this regard correspond largely to those in respect of the issue of special entries of irregularities or illegalities pursuant to Section 317 of the Criminal Procedure Act. The contentions advanced in regard to Section 319 were for similar reasons as applied to the argument under Section 317, devoid of merit. Briefly, firstly, the relief claimed by Mr. Zuma under this heading also concluded with a prayer that leave to appeal should be granted to the Supreme Court of Appeal in respect of the various questions of law for consideration by that court. The questions of law are suggested to include, inter alia, the irregularities regarding the fixing of the dates for the exchange of affidavits and Mr. Downer's alleged conflict of interest, which, as I've indicated earlier, were disposed of earlier in the judgment, and then also various other grounds which were not clearly stated. No application for the reservation of such questions of law had been made, and not having been made, could not have been refused. But insofar as the replying affidavit by Mr. Zuma falls to be construed as an application for the reservation of questions of law, that application too, in my view, lacks merit. No questions of law have been identified with sufficient certainty and with the required clarity necessary for the proper formulation thereof. In any event, where a question for the reservation of questions of law, or where a request, I beg your pardon, for the reservation of questions of law is refused, leave to appeal as now sought by Mr. Zuma is not required. He has specific remedies in terms of the provisions of the Criminal Procedure Act. The application accordingly falls to be dismissed on that score as well. Where that leaves us is that the criminal trial should now resume. It had previously been agreed by all the parties that the trial would proceed during the second and the third terms of the 2022 court calendar of this court, commencing from the 11th of April 2022, to which date I had in fact adjourned the trial on the 26th of October 2021. We shall reconvene for the trial to resume at 10 o'clock on the 11th of April 2022. The legal representatives of Mr. Zuma and Thales, that is accused number 2, must please ensure that they will arrange with their clients to be present in court on the 11th of April 2022 at 10 o'clock. That is the basis on which they had previously been excused from attendance. In conclusion, then, I issue the following order. 1. The application for leave to appeal and all related applications, which include the application to adduce further evidence on appeal in terms of Section 3165A of the Criminal Procedure Act 1977, the application for leave to appeal to the Supreme Court of Appeal on the grounds of Section 317 of the Criminal Procedure Act 1977, and stroke all for a special entry of an irregularity or illegality to be made on the record, and the application for leave to appeal to the Supreme Court of Appeal on the grounds of Section 319 of the Criminal Procedure Act 1977, and stroke all for the reservation of questions of law for consideration by the the Supreme Court of Appeal, are all dismissed. 2. The criminal trial shall proceed during the second and third terms of the 2022 court calendar of this court, where it has been set down as previously agreed by all the parties, commencing at 10 o'clock on the 11th of April 2022, being the date to which the trial was previously adjourned in terms of my order issued on the 26th of October 2021. That concludes the summary, and I repeat the invitation to any party to request a copy of the electronic version thereof from our registrar who is present in court. Court will rise.
Yeah, please. You're going to ask for an email also. Thank you, Mr. Chushini. Okay.
That's what we expected.
Okay. At least we're primed for it.
Yeah.
Your father,
Yes.
la es cool.
Mas essa curva, vocês estão